Hello, on behalf of the Academy for the Practice of Law, I welcome you for a special episode in a series of interviews about the privacy law. A lot is changing as of the 25th of May, and today, from a very special location, we will talk about all these changes. This special location is the Pieterskerk, the Pieters Church in the heart of Leiden, and this is a perfect place to discuss all these changes with Wouter Seinen. Welcome. You work for Baker McKenzie. What is your core business there?
I'm doing everything related to data, essentially. So this is starting from real technology practice, and more accent was put on protection of personal data because of this new regime.
If you talk to companies, organizations, what is the first thing you mention to them about changes that are coming as of the 25th of May with this new GDPR?
Yeah, I'm trying to explain that it's becoming real for them because the laws were already out there for ages, but due to the enforcement climate, it was not really a big thing. It was below the radar of most of the executives and even council. And many of them have now heard some rumors about a geeky new law in Europe, which should be more aggressive to them. But the majority of companies outside Europe really haven't a clue.
And there is a stick, $20 million, euros, I should say.
Yeah, so
fine
the new fines, that's absolutely what's now creating attention.
That wakes them up.
It's absolutely a very effective wake-up call for a lot of...
Okay, you suggested to us that we should talk about when is the GDPR applicable for companies outside the EU. Why is that important?
It is one of the new things, and that's why it's important. And it's important because it's now affecting companies that would normally think, I'm based in America or I'm based in Rio de Janeiro, so why should I bother? And it is a relatively new phenomenon. We learned that in Europe from the Americans who have the FCPA and FATCA and a couple of other laws which apply everywhere in the world under certain circumstances.
Were we tailing? Were we behind? Were we not as up-to-date as they were?
Yeah, you could say that. I mean, they were the innovators. And Europe tried to use the same concept now, and because this is rather a new thing, a lot of companies outside Europe are just not aware this is happening, or they know it's happening, but are not aware that's really happening to them. It's impacting their commercial interests.
Well, not only their commercial interests, because there's also like an ethical part of this whole new law, right?
Absolutely. So that's another aspect.
Well, they don't care about the ethics. They just need to.
Well, it really depends.
Get their act together.
So it depends. Most of the companies are busy enough trying to be compliant, and they apply their own ethical standards, and some of them may be in line with what we consider compliant in Europe, and sometimes it's just not. Simple example, the idea of what privacy really means, for instance, privacy on the work floor, is totally different in the US or in Brazil than here in Europe. So if you act responsibly and normally and ethically sensible as a US company, that doesn't really mean that you are automatically compliant with the laws in Europe.
Is there culture-wise a big difference when it comes to the thinking about and of privacy?
Absolutely.
What are the main differences?
The main problem for a lot of high educated people in companies outside Europe is that, for instance, they think your or my email address or name, that wouldn't be something which is sensible and sensitive in any way. It's just your name or your email address. So that's not covered by privacy laws, right? And here in Europe, we say, yes, it is. Similar mistake which is often made outside Europe is how to go about public information. It's on Google or it's on the internet, or so then we can just use that information.
So do these companies feel that within Europe they went overboard? They went, they're too strict, they're to a maybe ridiculous level even?
Yes, there's a lot of people out there who consider that ridiculous, and they do have a point, because it's really way beyond beyond their normal expectations and what they consider ethical.
What is the danger from a legal point of view, for companies who, within the management teams, have this thought of ridiculousness in the front of their heads?
It's the risk of being ignorant and not realizing that there's work to do.
So you might say, okay, you can think what you think, but this is just how it is, so comply.
Exactly. That's the main message. And
so
I'm trying not to raise panic or sound too alarming, because it's not always so complicated. A lot of things, because that's also an issue with that approach to radicalize things. Even if the processing of your email address or my name or your contact card is subject to the law, it doesn't mean that you cannot do it. You just have to meet certain requirements. So I'm trying to tell my clients and my relationships the other side of the ocean that this is something for them to grasp, and that there's ways to go about it.
Are these companies ready when it comes to the 25th of May? Or are they waiting for big fines to come?
They're definitely not ready, but that's not so surprising, because most of the European companies aren't even ready.
So you tell them not to panic, don't worry, you will have another year, or what? It starts at the 25th of May.
Yeah, I'm telling them to hurry and to at least put this on, create action items, know what to do, and set priorities. So I'm not telling them that they should do everything within a couple of months, because that would be really out of line. And I do not think that foreign companies will be fined right away the first day after 25th of May. But they are exposed, so they really should get going. If you just ignore the fact that the law is out there and then you should comply, then you will really deliberately create a risk as a company.
Do you tell your clients that this is the final step? There won't be any other thing changing soon, or you warn them, well, this might be even the beginning?
It is the beginning in many senses. So first, the homework for most companies is to really create an agenda, action items, and first start with the highest priority activities. And then there's a lot of other laws coming along the same path. So there will be more European compliance work for them, but I'm not always there to tell them that future, because the immediate future is already challenging enough.
Okay. Wouter Seinen, thank you very much for coming to the Pieterskerk, the Pieters Church in Leiden. And on behalf of the Academy for the Practice of Law, we thank you for watching.